or is dead. Oh yeah, so if it's not there, it means he's dead. So if your father is dead, it goes to your mother. In that order. So it means then if your father is there, it will go to your father. Everything will go to your father, and it is your father who will decide what to do with it. It's very important. So if your father is alive and doesn't like your mother, and you love your mother very much, under the law, it will go to your father. And so if your father is dead, it will go to your mother. Okay? So it will not be mother first. You can, because you're dead and you did not write a will, so it happens as the law would want it to happen. So father, mother. If mother is also dead, so father is dead, mother is dead, it will go to brothers and sisters and children of your brothers and sisters in equal share. So if you have 4 brothers, it would go to 4 brothers equally. So if you had 4 cars, each would get 1 car. Okay? If you had 4 homes, each would get 1 home. So brothers and sisters in equal measure. There's no brothers getting more, sisters getting more. If you don't have brothers and sisters, then it would go to half brothers and half sisters. So the law calls them half brothers, half sisters. But then here, you know, we are talking about cousins. Yeah? And children and any child or children of the deceased in equal shares. If then those ones are not there, the relatives who are in the nearest degree of consanguinity, that is the closest relatives, the ones after cousin, the one who would come closest. And in my analysis, then it would be your uncle and then your aunties. Yeah. And I don't think it would go beyond there. And if you don't have those, then it goes to the state and it will be paid into the consolidated fund. Angie, I don't know if I've responded to your question adequately, also in the interest of time.
Thank you. Yes, you have. Maybe I have another question. So when it comes to still on intestacy, what do you have to say about illegitimate children? And then I will have Rogers, you can ask your question. Yes, Rogers. Rogers is our co-founder also. Rogers.
Thank you, Claude, for the very comprehensive presentation. My question was in regard to, let's say in the context whereby somebody is making an oral declaration, maybe to the advocate in the presence of 2 people for it to become a written will. But then in the process, they do not sign the written will. Can such be adopted as an oral will? Those declarations that he made.
Okay, come again, please, just for clarity. Rogers?
Yes, can you hear me now?
Yes, I can hear you. I heard you. Just come again, just so that I'm very clear on the people, so that I respond. Yeah.
So somebody is making oral declarations to his advocate in the presence of 2 people, and he intends it to become a written will. But in the process, they are not able to sign the will. Maybe the testator dies. Can such be adopted to be an oral will? The oral declarations that he made.
Thank you. And I think that one is more of from my understanding, because then the law does not clearly provide for that scenario. And then we'll analyze that scenario based from my understanding. And so, number one, I would say, you see, whether a written will or an oral will, at the end of the day, then a will is an expression of the wishes of what should happen with regard to property upon death. Yeah, and so that's why we have an oral will and we have a written will. However, with regard to oral wills, we know number one, they're only valid if the person dies within 3 months of making the oral will. Yeah, unless of course it's a soldier in active service, where then that is extended to the period of active service. But here, this person, I'm assuming, is not a soldier. So if this person dies within 3 months, and the fact that then he made these expressions and there are 2 people who are competent, if we can establish their competence, number one, they have age, number 2, sanity of mind. So in that they will be able, that they heard what he said, they understood what he said, and they can relay what he said, and it was done in the presence of the 2 of them. And of course, then the advocate then becomes a third person, and this person dies within 3 months, and I think that would suffice as an oral will. That is from my analysis. Yes.
Okay, thank you.
Angie, you have brought up a very interesting discussion illegitimate children. Illegitimate children. And we use the word illegitimate, for lack of a better word, not with without prejudice whatsoever, by which then we refer to children who have been born out of wedlock. That is one of the challenges, and I stand guided here maybe by any lawyer then who has done far more reading than I have. But one thing, and that is why then I would push any of us here to write a will, because then, and then the gentleman in the house then can hear me, because then the Law of Succession Act, which is a guiding law on matters of succession, does not, under intestacy, does not expressly factor illegitimate children. The conscience of the court in certain circumstances, I am not very sure how the courts have exactly dealt with matters of intestacy, yeah, but as compared then to testacy, where you write a will, you see, as a will, I could have an illegitimate child. It could be something that happened when I was in campus, and I got you know, I got someone, I got a boy or a son with someone, and we never really got married. We never got it into a marriage, but then I have a child outside there. I could be, I pay his school fees, I take care of him. But then in the context, he was born out of wedlock. So of course, then the law does not expressly factor that person in there. Yeah. And in a will, you can provide for them. In a will, you can provide for them. And even if you do not provide for them in a will, when you look at testacy, that is where someone dies without a will, with a will, even if they do not benefit as an heir, they might be entitled to benefit as a dependent. You might not put them as an heir, but they will still come before the court and challenge on the basis of dependency that I was depending on this person. And with children, then Section 29 is very clear. It matters not whether the deceased maintained these children before his death. It doesn't matter. So it could be, I have never taken care of you in your lifetime, but then I die. You can come and petition to the court and argue that I should have provided for you and that you are entitled to reasonable provision. You're entitled to reasonable provision under my will. Yeah, that is as compared to intestacy, where it simply looks at the wife, the children, and looks at what we are calling the family. I will call it the family tree: father, mother, brothers and sisters, half brothers and sisters, nearest degree of consanguinity. If none of them, it goes to the state. Angie?
Thank you so much, Claude. We'll have our final question from Brenda Mukami. Brenda, you can unmute and ask your question.
Hi, Angie. Thank you very much for this time and opportunity to be in this space where my counsel Kandem, who happens to be my good friend and classmate at one point, is presenting. And my question is in regard with the question that Rogers asked earlier on the, you know, a will that was made, but the witnesses were not able to, attestation was not, did not happen, and the testator died before that happened. And the question was whether that can pass for an oral will. So my question or concern was, in the event that that will was written and it has not been attested, and rather the statements have been made. Okay, let me just put my thoughts together and frame my question. If at all that is going to be an oral will, will it not require to be in tandem with provisions of section, I think that is section 9 of the Law of Succession Act, where it requires that there be witnesses in place, or how will that happen? I don't know whether my question is clear.
Yes, Brenda.
The audience.
Your question is clear, and maybe for purposes of the audience, then I'll just recap the question.
Thank you.
So you're asking then that I have in answering Rogers, I did say then if Claude walks into Angela's chambers and expresses what he wants, and he wants Angela to write a will, but as he's expressing what he wants with regard to his property, there are two people inside Angela's office who then hear what Claude has said. And maybe the lawyer, Angela, was taking it down, but then Claude dies before he's able to sign. Will that be an oral will? And I have said it will be an oral will, number one, because it is an expression of intentions upon death. That is number one. Number two, it has been witnessed. But then Brenda is asking, what if there was a written will? It was actually written. Yeah, it was written. By the time it was being written, then these two witnesses were not there. And so the witnesses are brought into the scenario later on after the will has been written and Claude never signed it. Can it be an oral will? Brenda, I've captured it correctly, right?
Yes, whether even if he signed it, even if he signed it, the point, but that is the question, correct?
Okay, all right. It cannot be an oral will.
All right.
It cannot be an oral will because if we just read and you refer to section 9, let me just get the act. It says, okay, form of wills or oral. Anyway, the two key elements then in oral will is that at the time of making that oral declaration, for it to pass as an oral will, at the point of making that oral declaration, those two witnesses must have been there. You see, when this poll come later on, even if Claude had signed and it is written, they were not there when he was saying those things. So they cannot confirm. It could be what Angela has decided to put down in writing. Yeah, there's no guarantee that that is actually what Claude said. And if we talk about then the fact that Claude signed, remember now when you go to a written will, when you go to the aspects of a written will, and it is Claude is still supposed to confirm his signature to the witnesses. It's not just to be shown and told this is Claude's signature. Even if they know Claude's signature, Claude should either be the one to tell them, I'm the one who signed here, and so sign in confirmation that I'm the one who signed here, or sign in their presence. Yeah, that is my view on that question.
Oh, thank you so much. So Rosemary, I think it'll be the last one. Yes, Rosemary.
Thank you once again, Angie. I'd like to add on to what Brenda and Rogers has asked. You can also look at the intention of the testator or the testatrix. So did the testator intend the will to be oral, or did the testator intend the will to be a written will? So that is how one of the ways that you can differentiate, even though the testator went to the chambers and died even before attesting to the will. Thank you.
Thank you, Rosemary.
So any final remarks from Claude? Then I can give the vote of thanks.
None. I think this topic is quite wide. Might need to have a follow-up on it, but as a demand so requires. But thank you very much for inviting me, and I hope guys have been able to learn something. It was really fun doing this. Thank you.
Thank you so much for agreeing to come on board. We are so happy and blessed to have you. So I also want to thank our participants who are around 26. Thank you, each one of you, for sparing this Saturday evening for this 1 hour and just coming to learn and to engage. It is one of the things that make us smile at Sharia Clinic, is to be able to impact people with legal knowledge, so that when things happen, you're not there, you don't even understand anything. At least you have some legal knowledge. So thank you to the 26 participants. Right now we are 21. I think it's because of the news, but it is well. Thank you so much, Wakili Claude Kandem. We will surely have you come again and again, not just once, more than once. And thank you. So the recording will be up on YouTube as soon as probably next week, so that you can be able to watch it and even take down notes for those who want to. So with those few remarks, I want to close the meeting and wish you all a good evening and a blessed weekend. Till next time. Thank you.
Thank you. Bye.